Before we take up this question for our decision, we must consider some of the principles to be governed for allowing an amendment of the pleadings. It is well settled by various decisions of this court as well as the high courts in India that courts should be extremely liberal in granting the prayer for amendment of pleadings unless serious injustice or irreparable loss is caused to the other side. In this connection, reference can be made to a decision of the Privy Council in Shweta Roy vs. Madurai, Year 1932, PC 249, in which the Privy Council observed all rules of courts are nothing but provisions intended to secure the proper administration of justice, and it is therefore essential that they should be made to serve and be subordinate to that purpose, so that full powers of amendment must be enjoyed and should always be liberally exercised, but nonetheless no power has yet been given to enable one distinct cause of action to be substituted for another, nor to change by means of amendment the subject matter of the suit. Keeping this principle in mind, let us now consider the provisions relating to amendment of pleadings. Order 6, Rule 17 of the Code of Civil Procedure deals with amendment of pleadings, which provides that the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. A bare perusal of this provision, it is clear that the Order 6, Rule 17 of the Code of Civil Procedure consists of two parts. The first part is that the court may at any stage of the proceedings allow either party to amend his pleadings, and the second part is that such amendment shall be made for the purpose of determining the real controversies raised between the parties. Therefore, in view of the provisions made under Order 6, Rule 17 of the CPC, it cannot be doubted that wide power and unfettered discretion has been conferred on the court to allow amendment of the pleadings to a party in such manner and on such terms as it appears to the court just and proper. While dealing with the prayer for amendment, it would also be necessary to keep in mind that the court shall allow amendment of pleadings if it finds that delay in disposal of suit can be avoided and that the suit can be disposed of expeditiously. By the Code of Civil Procedure Amendment Act 2002, a provision has been added to Order 6, Rule 17, which restricts the courts from permitting an amendment to be allowed in the pleadings either of the parties if at the time of filing an application for amendment the trial has already concerned